Good morning, everybody. We're just going to give you a couple of moments for a few more people to join. We can see the numbers are just starting, so we'll let everybody get in before we get going this morning. Just see the numbers ticking up now, so we will say good morning, everybody. Hope you're all doing really well. I'm Ruth Mullen from the employment team in our education team here at Forbes, and I'll be hosting for you this morning. With me, I have Laura McHugh, who is also in our employment team, and our partner who also does FE and HE work as well as our schools work. We've also got with us Gemma Duxbury this morning, well known in our education sector for all things governance, data, all the really interesting stuff that Gemma loves to bring to you. And we have with us as well Sharose this morning. Sharose is our litigator. He's the man that we roll out when we have some real tricky issues, and is very adept at working with our schools when he's needed. And last but not least, of course, is our colleague Sam. Sam works in our property team. Again, all things schools related. We were just talking about this before we started. When you're buying or selling land, or you're transferring land, or you've got problems with land, Sam is your man. So it's really good to see you all here this morning. We've had some questions come in prior to the session, which we're going to touch on this morning. And then obviously, as we go through, please do feel free to pop any questions that you've got into the Q&A, and we will endeavour to answer all of your questions as we go through. So I think this morning, Gemma, I think we were starting with you.
Oh, yeah.
Which is the question that's come in is about what the current landscape is at the moment in relation to maths since all the changes with the government. I think people just want to understand where we're at.
Okay, thanks, Ruth. Good morning, everybody. Lovely to see, well, say see, but you know what I mean. Nice that you're all here. So, yeah, effectively, it's all sort of kicked off a bit recently. A few sessions ago, we talked about the children's wellbeing in schools bill in quite a lot of depth. And there seems to be a bit of a shift away from academisation. Well, that's how it was perceived. However, at the moment, I can say that they are still happening, they are still ongoing, new applications are still going in and still being processed. This is even though the original contribution towards finance has now gone. People are looking at alternatives. The way it's sort of been considered is that really, rather than getting rid of academisation, so to speak, it's more of a pause, because government were at the stage of, right, well, this is here, it's come about, it's happened, we can't really go back on it, we can't backpedal, but actually what's going to be best moving forwards, because I don't think that necessarily academisation has brought the results that they wanted. So at the moment, I can tell you that I am still as busy, I am still doing conversions, I am still speaking to clients that are starting new maths, that are still proceeding down the academisation route. Obviously, with the children's wellbeing in schools bill that's loitering in the background, there are sort of several changes relating to that, which may also have an impact. And I think local authorities are now going to be a lot more involved, perhaps, in the process. So if you remember when we spoke about it, local authorities are getting some powers back, and they will have a say in putting forward proposals to the Secretary of State and the DfE as to what they think should happen to schools. And that means that academisation isn't off the table, but it is potentially, if depending on what the position is and whether or not that's the right option for them. So at the moment, all I can tell you is it's still happening. I did sort of do a bit of research on it. There is a real concern, I think, by a lot of trusts with regards to the financial position due to the retraction of that startup grant or that conversion grant that was originally in place, which was the 20 to 25k that you could get for that. People that I'm advising, I'm sort of saying, well, you know, with all due respect, the DfE are going to have to do something about this. I think something is going to have to happen, and we're just going to have to look at it on a case-by-case basis, have that conversation and see whether or not there is any funding available. And I think that would just depend on the circumstances per trust. I think MATs think that they are financially vulnerable because of this and potentially may be holding off doing future conversions. I think the whole idea behind it, being blunt with you, was that a lot of these really large academy trusts that are in place, it was seen unfair that every time they were getting a new school and they were getting additional 25k in the pot, when actually they've got potentially enough finance to be able to bankroll it themselves. Whereas you have the smaller new MATs or the ones that only have 2 or 3 schools. And really the idea of the grant was that it would be helping you on that side of things. So I'm not necessarily convinced that it's going to be the end of any sort of support or help from the DfE. But obviously, MATs are still there, they're still happening, academisations are still happening. And that white paper that was still released in 2022 was saying that all schools were to join these strong MATs. A lot of people are sort of saying that goal is just not achievable now unless academisation continues or there are mergers. And we've just got to, I think, take it a day at a time, wait and see where this goes, and hopefully a solution will become apparent, and hopefully they might make it more so that funding is available in certain circumstances, but we will just have to see.
Thanks, Gemma. Well, that's a whistle stop of where we are with MATs at the moment. Obviously, if you do have any questions, do pop them on the Q&A and we'll come to that shortly. Me having just realised that I can't see any questions on the Q&A, so I'm going to ask Gemma to keep an eye on that.
No. The worst technological person to do this.
And I know that Sam had a question posed to him as well. Sam, there was a question about the new land questionnaire that the DfE have introduced. And I think you had some things that you wanted to tell people about that to look out for.
Yeah, thanks, Ruth. It was just to provide people with a bit of an update around changes to the land questionnaire that's used as part of the academisation process. The DfE have published a new form of land questionnaire, which is to be used. You may be aware, you may not, but the land questionnaire is a document that's used by schools when converting as a way of providing information regarding land that they own and the school site in particular to the DfE. It tends to be completed and submitted ahead of the conversion as part of the overall process. The form itself was updated in April last month, so it's to be used from the 2nd of April. And there are a number of new questions and considerations that we wanted to bring to your attention. It should be said, obviously, as property solicitors, we're here to help, and we can provide some of the required information on your behalf. But there'll always be questions which are site specific, and therefore we rely on answers that are provided by the schools themselves. So obviously the update is relevant for schools thinking about converting, and also for existing academy trusts that are looking to add new schools to your group. I think it's also important to note that it emphasises those property issues which the DfE consider important, and which all schools and academies ought to have a firm handle on. So even if it's not something that falls within your role per se, it may be worth making your estates manager aware of the update, so that they can take a look and have consideration to any issues that may arise, and if needs be, reach out and have a chat with us about those. So in terms of the changes, there's now a focus on temporary sites. So there's a new question asking for confirmation of whether the school or any part of it is located on a temporary site. It's quite a niche question, which might not be applicable to all schools. However, it is relevant where building works are being carried out to the main site, conversion from a separate site until those works are completed. If that is the case, then the DfE now require information about when the school will move to the new site, who currently owns the new site, information about access to the new site. Is the road the access road and unadopted highway, and what arrangements are to be in place when the school does transition across. There's also new questions regarding dispositions, so transfers, disposals that may require additional consent of the Secretary of State. Example of this could be where a school following conversion is looking to grant a sublease back to the local authority, and therefore additional consent is needed for that. I think the aim of that question is to make the Secretary of State aware of any planned dispositions ahead of time, so that the consent can be prepared in readiness, and hopefully that will enable the academisation process to become more streamlined, and so there's less delay if any leases need to be granted upon conversion. There's also a number of new questions regarding shared usage. So questions regarding shared uses were included in the old land questionnaire, but there's perhaps the assumption that they only related to, say, use of the playing fields or leisure facilities. The DFE have now clarified that shared use considerations also applies to minor easements or any third-party use of the school site. So that could include electricity substations or weather stations, as well as rights of way that might be enjoyed over the land. We'd normally expect to uncover things like easements and other third-party rights that affect the school as part of our report on title and the pre-conversion searches and investigations that we carry out. But it's important to note consideration will need to be given as to the nature of these agreements and whether and how the current shared use arrangements will continue after conversion. Another new focus of the land questionnaire is around access to your school site. There's new questions in relation to the roads leading to your school. For the most part, they're not unusual or particularly difficult questions to answer. And they're designed to kind of confirm the position in relation to whether the road forms part of the school land, if it's adopted, and if other parties use the road. I think the intention here is to prompt schools and trusts to consider at an early stage whether rights to use any access roads will need to be included in the lease for the school site. Will the school be required to contribute towards its maintenance and upkeep if the road is unadopted, if it's a private road, and also whether there's any grounds to require other third-party users to contribute towards the maintenance and upkeep as well. A new section has been included in relation to caretakers' homes, which I know can often crop up. As part of the new questionnaire, there's specific questions relating to caretakers' houses, the basis on which they're occupied, and how it's proposed that they'll be treated post-conversion. We often get asked questions regarding caretaker homes and the status that those enjoy. We'd normally assume that the basis on which a caretaker resides at a property on school grounds is under what is known as a service occupancy. This means that the use of the caretaker's house is tied to his or her employment. It may be that the need to reside at the property is essential to the caretaker's role, or alternatively that there's a requirement for them to live there in their contract of employment for the better performance of their duties. If that's the case, the caretaker would normally occupy the property under a licence as opposed to any kind of residential tenancy, and they'd only be permitted to live at the property so long as they remain employed in their role. If, however, the need for the caretaker to reside at the property is not essential, or it's not referred to in their contract of employment, then it's likely that they'll be deemed to be occupying the property under a service tenancy. So that would give them a right to occupy the property, which is independent of their role as a caretaker, and therefore those rights would continue beyond their employment. They'd be able to continue living in that property until that tenancy has been brought to an end in accordance with the usual procedure for terminating residential tenancies. And finally, there's some questions, expanded questions around capital funding and building works. There's always been questions in the land questionnaire about building works that are either to be carried out or that are due to be carried out but the new version of the questionnaire asks for more specific information around funding and estimated completion dates. So it's important to obviously have that information to hand from the outset. I think for the most part, the changes to the questionnaire are relatively minor. As I said, some questions have been carried over from the previous version in relation to things like nurseries, children's centres, community and third-party use of leisure and sports facilities. So there's plenty there that was there before. And most of the new questions, I think it's fair to say, would have likely have been picked up under the old form of questionnaire. But by including these specific questions, it seems like the DFE are going to require more detail to be given to them at the outset. The aim being that they can then assist with any potential complications in the property arrangements as early as possible. So if you're looking to academise, considering adding a new school to your existing trust, or if anything that I've mentioned has either piqued your interest or got you thinking about your own school site, we're always happy to have a talk through any title or land related issues that you may be experiencing. So by all means, drop me a line or reach out through the Q&A.
Brilliant.
Thank you very
Thanks,
much.
Sam. Thank you very much. So moving on to a different topic now, we did have a question in from someone who was new to our Q&A. So welcome to that individual. And one of the questions was around equalised pay and the different nuances in employment law and education and what they would need to know. That is quite a big topic and we could be here for probably about a week. But I thought it would be useful to just kind of, I suppose, point out a couple of things just really to get that person having a think about what might crop up. So one of the key things is pay. Obviously, pay in the education sector is dictated by various schemes of pay, progression, how that operates. It's often negotiated as part of collective agreements with unions. So there will usually be particular pay scales that need to be followed and very specific rules around that. So it should be the case that if those are followed, and I did read something yesterday that said that's going to become more and more relevant as well to academies, because academies haven't had to accept the kind of standard teachers' terms and Burgundy Book provisions for pay previously, but I think it was in the Children and Wellbeing Act they talked about perhaps going back towards that and a bit more of a shift, which I think chimes, Gemma, with what you were saying about more of that local authority power shifting back towards academies and support there. In experience, a lot of schools haven't really stepped away from those ways of making pay work anyway, because I think a lot of people have taken the view, well, if it's not broken, let's not fix it, because it is difficult to then write your own pay scales and make sure that they fit. And also from a retention and recruitment point of view, it's really important that people kind of know where they're going and what they will be on. So I would hope that equal pay, in effect, as a claim of potential discrimination, isn't something that should feature heavily. Occasionally it will if people are on different bandings, but I would hope that wouldn't necessarily be a huge issue. There can be issues around harmonisation of terms if you've had a TUPE transfer. So, for example, if you have a school which has gone into being part of a MAT or has left the MAT, you will very often have a TUPE transfer happen there, and that can give additional protections. So that's something else to look out for. I suppose one of the other specific nuances is really around things like sick pay, holiday leave, because obviously most schools don't allow holidays to be taken other than outside of term time, and notice periods are very specific. Notice has to be given at specific points in the year, depending on your grade as teacher, and that can affect when people leave or when people move on. So I think that's probably some of the key things in a nutshell. What I would say to that person is welcome and thank you for coming. Keep listening. Obviously, if you've got any specific questions, you can drop us a line through the Q&A, or you can contact us out offline as well. And we'd be more than happy to have a brief chat if there's anything that you are particularly stuck on. So enough of my voice. We're now going to move over to the dulcet tones of Sharose, who is going to tell you all about, I think, supplier contracts today.
Yeah, that's the one. Yeah.
Brilliant. Thank you.
No, thank you. So, like any business, of course, we all have many terms and conditions, many different contracts, many supplier agreements that we often don't pay any attention to until we really need to. They're often up for renewal, and many have auto renewal clauses within them. Without us notifying our suppliers in a certain manner, some of them are unfavourable terms to us. But because of convenience, we just allow that to keep happening. I think now is a good time for us all to just take a step back, look at them contracts, see when they're A, expiring, and B, what's required from us in order to either renew them, not renew them, or look for more favourable terms. And we've had a query just this week where a client has reached out stating that a supplier wants them to vary the terms, but without any notice. So we've had a look at the contract, and there's a clear format, clear process that needs to be followed before the terms can be varied. But the initial email from the supplier was so strongly worded in a very formal manner, where you'd just assume that the format that's been presented is, this is what the new position is, and these are what the new terms and conditions should be. When we looked at the agreement, we quickly realised that isn't the case. There's a whole process that needs to be followed, and there's no right for the supplier to vary their terms despite the initial correspondence appearing to be that way. So I guess the quick overview from me is look at them terms and conditions. And if you're unsure, by all means, reach out to myself or one of the team, and we're more than happy to assist, because 9 times out of 10, and that isn't an actual statistic, but there'll always be something in there that isn't correct, and parties have just been working on a basis of what they assume the decision to be. Ordinarily, yes, a discussion can be had and you can sit down, but you should really be looking at them terms and making sure you comply with them as best as you can. So that's a quick overview of the position there.
I think this is a really important subject to talk about, because I've had a few recently clients contact me with regards to, I think suppliers now are getting savvy to the conversion process. So what they're doing is, some schools which at the time of maybe thinking about joining a trust or converting, they're getting tied into these contracts. So there's quite a few providers that, so for example, a trust that recently brought a school in, they only entered into this contract about 6 months ago, but they've actually inserted clauses in now relating specifically to conversion, and the fact that basically you have to pay them to get out of the contract, or it has to transfer over. There's sort of no choice. And obviously a lot of the trusts already have existing contracts in place with other providers. So it's I found it really interesting seeing that kind of switch where they've now got savvy to it, and they're actually tying people in because they know when these schools join a trust, potentially the contract's going to be ended. So that's quite interesting that I've been seeing that. I think that's a new thing.
It is, yeah.
Yeah.
I'll show you.
I'll show you. I'll send it.
I think it's really relevant as well, because if you think about, I know myself, if you look at your household bills and how much they creep up at certain points in the year, your broadband, your mobile phone contracts, all this sort of thing. I think the issue is for schools, you've got that overriding principle all the time of value. Are we getting best value for money? Are we finding the right things? And no one's saying if you're happy with the supplier, move away, because sometimes the value of that relationship can be important. But I think what we're saying is, look, do look at it. Don't just accept what they're telling you as being so. Question it. I think our moral, isn't it, as litigators, is don't trust anyone. Don't trust what they say. Evidence it for yourselves. So if you do have those questions, we've got an expert team over here, 2 of them talking about that. Please do feel free to get in touch.
I got look at it. He argues about it.
I mean, that's a really good summary, isn't it? Yeah, it's a really good summary. I'm just going to go to Gemma and ask, have there been any questions?
There was. Let me just check.
Oh, we're going to check.
I am the wrong person to be doing it. Yeah, no, it's we have no questions at the moment. If you'd like to raise any questions, as you can see, I'm on fire. Oh, hang on, there's some cropped up now. Is that you, Ruth? Or have you done
No,
that
it's
on
not
purpose?
me.
Have you done that on
It's not me.
purpose? No, there's nothing in the chat box at the moment. No, none of yet.
Right, I'm
Yeah.
playing for time because I'm looking for something on my laptop as well. I'm going to.
As you can tell, we're the spearheads of
Well,
IT at Forbes.
There was something else that I wanted to just touch on that had come to light and generally involved something we were talking about for a client last
She
week.
does this to me all the time.
I'm throwing her a curveball now.
Ah.
So we came across an issue with one of our schools where there was a question mark over who the correct employer is. And that happens actually more often than you'd think. And it can depend on your type of school. So in an academy, it's always going to be the trustees. So that one is quite simple. If you have a local authority school, that they are a maintained school, but they are maintained in different ways. And depending on which way they are maintained, dictates who the employer is. And you will only really know that if you've worked in one of those schools or you are one of those schools. But also we have sort of independent schools that sit outside of that, some in the charitable sector, some in the private sector. So it's really important to have this process of governance. And this is what I kind of wanted to touch on, was to say, when Gemma and I looked at this, it was following the trail of evidence of the governance and where the company is, the company, does that sit there, and how we look at that. So if that again is an issue for you, it isn't something that crops up all of the time, but it is something that crops up more often than you would think. It's always really important, I would say, Gemma, from a governance point of view. I didn't know if you wanted to just touch on that.
Yeah, no, it really is, because and this is the complications. Obviously, there are lots of different types of schools. And particularly, a lot of the time people think it's a maintained school. Oh, well, the local authority is the employer. And that just isn't necessarily always the case. It could be the trust, it could be the local authority, or it could be the governing body. So it does depend very much on a case-by-case basis. Then obviously you have your religious designated schools, you have your foundation schools, your VA schools, your VC schools. So there's all different types. And that was quite an interesting case, wasn't it? Because everybody seemed to think that it was one thing, and actually, when we dug down into it, it was a different thing. And sometimes it gets down to literally, well, what's on the people's pay slips? But even then, that might not necessarily give you the answer, because even though somebody might have put their name on the pay slip as the employer, they might actually not be the employer. So it is really, really important. And that's part of whenever we do the conversion process or deal with any sort of these tricky employment queries, is that we do have to sometimes dig down into actually that who the governance structure and also schemes of delegation and things like that. So it's a really important point. She was testing me on that last week. She was
Brilliant. It's brilliant. And I suppose it's a good time to mention as well, we have another colleague who has joined us within the firm, and she will be, I hope, on the next Q&A. Unfortunately, she wasn't able to be available today. A lady called Emma Swan, who also has loads of experience in the education sector. So she deals with all kinds of nuanced things. So the different queries that you get, if there is something and you don't think that it can be answered, please feel free to challenge us. Not necessarily on the Q&A, I'm going to answer very quickly. But, do let us know, because we do have, as you can see today, a number of experts in the room and around the firm who can actually help with all things education. So please do feel free. And you're all being really quiet this morning, so please send us some Q&A questions through. Go on. I know you've got some questions in there. And let's test Gemma's technical expertise. So Laura and I wanted, is probably a stretch, to talk to you about the recent ruling and putting a bit more, I suppose, of a serious head on the recent ruling around where we stand now with a woman being a biological woman, which has come out from a case that was determined just a couple of weeks ago. As you would expect, we're not in a position to quote the law specifically yet, because what has happened, I suppose, a little bit curiously, is we've got legislation which says certain things, case law then goes and determines how that's interpreted. And there was a case by it was Women Scotland Limited and the Scottish ministers who were challenging the definition of what a woman should be under the Equality Act. Now, you will have heard a lot about this in the news, and there is a lot floating around at the moment. I am going to say there have been a number of articles that have been published by other law firms, which have very quickly been withdrawn. And the reason for that is, at the moment, we are in a little bit of limbo. It's been presented that this case has just simply determined how it is, and that that's what we're going to have to do. The difficulty at the moment is the Equality Commission for Human Rights has decided that they need time to look at this. They are going to do it fairly quickly compared to how things normally move in the legal world. But what it means is we've got limited information to provide you at the moment. Now, the timescale on that seems to be they're going to a very quick consultation of something like 2 weeks, which is relatively unheard of, with a view to updating their guidance. And we're hoping that's going to be around June time, which brings me on nicely to say our next Q&A session is, I think, the 26th of June. So we would hope that by then we may be able to bring some further information to it.
It's hitting the sports world, isn't it? A lot.
Well, it's hitting all sectors. And this is the difficulty, because essentially the ruling is, previous to the ruling, the law said you could obtain a gender recognition certificate to be treated in your acquired gender. So if you were 18, you could get this certificate, and then let's take the example of a biological man who has acquired the gender of a woman. You would then, for all intents and purposes, live as a woman. Now, this case has kind of thrown that really into a bit of doubt, because it's looked at what the definition of man and woman should be in accordance with the Equality Act. And what they've said is that in the Act, woman is described as a female of any age. And the difficulty is how that is now going to sit alongside the Gender Recognition Act. So that's it's a conflict of pieces of legislation, is the way that I would describe it. And it isn't the first time this has happened, because this happened with the religious and protected beliefs legislation, together with the sexual orientation regulation way back when. And many of you will remember it was framed as the gay cake case. I can't remember the name of the case, but it was referred to that because it was about a bakery, and it was about whether or not the bakery were required to make a cake which represented gay marriage. Now, that was long in the making, and the settled principles of law on that were that both parties were entitled to hold their own views, but what they couldn't do was discriminate against one another and breach the legislation. This is slightly different because it's an interpretation of what the law already said. The Gender Recognition Act then added an extra layer to that. But what this case seems to be doing is kind of unpicking what that means. So it is very tricky, and it will apply to schools, because we know that there is a lot of movement in schools at the moment towards supporting, obviously, trans students, and also we need to look at trans employees as well. I think it's fair to say there's a lot of unrest and upset in the media at the moment about this. And I think, to some extent, we are going to have to wait and see a little bit. That said, I think what we can do for the time being is talk about kind of where we are. So effectively, what has been cited by this case, and it's covered in the current guidance for the Equality and Human Rights Commission, that a woman is a biological woman or girl, a person born female, and that a man is a biological man or boy, a person born male. If somebody identifies as trans, they do not change sex for the purpose of the Act, even if they hold the gender recognition certificate. Now, what this means is, for those people who hold a gender recognition certificate and have lived in their acquired gender for quite some time, are going to find this extremely difficult, because what has been allowed to happen or permitted to happen at the moment may well change. And that is giving, I think Laura and I talked this morning, it's giving us a great deal of consternation at the moment as to where that will come. So in workplaces particularly, and you know, it's only one example of it, you have to have single sex toilets available to your staff. Now, previously, with the gender recognition certificate, in a lot of workplaces, trans women have been allowed to use the women's toilets. What this case appears to be indicating is that will no longer be the case, and that for them to remain single sex provision as required, according to the law and this case, that will no longer be allowed to happen. And the suggestion at the moment, and as I say, we can't give you any guarantees on this position at the moment because the guidance is only very temporary. And if you do want to look at it, it is there on the Equality and Human Rights Commission website. It talks about using a lockable room that can be open to any other any person, because what you then can't do is not allow a trans person to have anywhere that they can access facilities. So it would mean that a trans male cannot no longer use the male toilets. They would have to use the female toilets and vice versa, which seems to me quite a difficult challenge for people that you know, have been living that way for some time. So that is the kind of position as it stands now. Gemma's right, competitive sports now can be single sex and can be identified in that way, and it won't be discriminatory. My own view is that this legislation is really targeted at that, avoiding discrimination if you decide to have single sex provision. But also it seems to be saying that you can't not have it where it's compulsory to have it. So in services, you don't have to have it. And in schools, of course, you have your own rules in schools, and it will affect schools as well, because it's talking about, we have the single sex provision in schools anyway, but it's talking about then having an alternative accommodation for trans students as well. So it's not a settled position. It's really quite tricky. And I know, Laura, you were listening to a podcast this morning, so I bring you in to talk about this as well.
Yeah, I think we've got to remember that this has gone to the Supreme Court because at other levels, people couldn't come to the same decision on it. And I think what I was sort of getting the context of this morning in particular is when we talk about the Gender Recognition Act, which Ruth mentioned at the start, and that obviously says once you have the certificate, you become that sex for all purposes. But there is a subsection of that part of legislation which says subject to any other enactment. So that's what the Supreme Court were looking at, is whether for that purposes is the Equality Act another enactment. And they said, yes, it is. So they therefore, you know, really unpick the whole of the Equality Act. And I think that's what potentially the previous courts in Scotland in particular hadn't necessarily done when arriving at their conclusions. And I think the Supreme Court judgment, which, you know, it's 88 pages, there's a lot there just to decide whether or not, you know, we interpret one word in a particular way. But the court has said if you look at the Equality Act as a whole, it has to be that sex means biological sex. Otherwise, various different provisions of the Equality Act wouldn't make sense. And for example, the KCs that were on the podcast I was listening to today, one of them was the KC who was involved in the case. And she was making the point that if if sex is to be taken as certified sex, so if you get a certificate, that is your sex, that could actually mean a dilution of some rights for trans people. So for example, if it's a biological woman, but she may identify as male, she could still be in a position where she needs protection in terms of breastfeeding or pregnancy because she is a biological female in that sense. And if we were saying that the Equality Act should be interpreted as certified sex, and that person wouldn't have protection in relation to breastfeeding in the workplace, for example. So there's quite a lot more to it, I think, than we first think there is. You know, we think it's quite a narrow issue, but actually it is wide. And I think when you look at the different groups who are involved in the cases and the support of it, really, I think what's sometimes missed is that this is really about single sex spaces and some of the services that certain groups think should be reserved for females only, for example. But when we then lift that and put it into the context of a school who has perhaps a trans pupil who has been using a particular toilet for a few years and everybody is fine with that, and now it seems we have to change that position, that's where it's problematic. And that's where Ruth is right, that I think it's still about looking at things on a case-by-case basis, because there could almost be other risks if you go down that route from a protection from discrimination on the basis of the fact that gender reassignment itself is a protected characteristic. And I think the Supreme Court were trying to make it clear that they felt that the trans community was protected and that they have rights, and those rights are in the Equality Act. But it's left us in this very difficult situation. So I think it's a case of waiting for that further guidance, certainly from the EHRC, as the next step in deciding what to do.
It's a really hot topic though, isn't it? I mean, there's been talk as well that there's case law at the moment, or there's cases ongoing where people have gone through the process when they're quite young, and then they've decided to transfer back, and they're suing the doctors that originally signed off to say that they could go through the process. So it's this isn't just
Really
it's across the
difficult.
board, isn't it?
It's really complex, isn't it? And I'm sure our schools colleagues will be able to tell us many stories of difficult circumstances. I think the thing that really caused me some concern was, and I've got an article here where the British Transport Police, the day after amending strip searching policies, to say that male officers were carrying out searches on trans women. And I think if you've been living as a trans woman for a long time, or even a short time, but have known that you were going to go through that progression, I think it's really tricky. And I think it's tricky all ways round. I think it's tricky for everybody. It's tricky for those that want to be protected in a single sex space. It's tricky for those who, you know, are going through or have gone through the transition process. And, you know, I think we're going to have to really just have a watching brief. I think Laura's right. What we've said to clients so far is, look, don't take any knee-jerk reactions. Assess what's going on in your school, workplace. You know, is there any unrest or upset? Has anybody got any concerns about it? If that's being fed back to you, let's look at everything on a case-by-case basis, because at the moment, we think it would cause more harm to simply start changing things quickly. And from what we've seen, some organisations have started to change things really quickly and then have had to row back on it. So, you know, as Laura said, you know, trans people are still protected by the discrimination laws, by the gender reassignment provisions in the Equality Act. But some of the, I suppose, the provisions that they've had are possibly going to be rowed back on a bit. So we need to wait for the guidance and, you know, take stock really of what's going on. I'm just going to ask, have there been... Oh,
But there weren't, I checked just before,
Okay.
there weren't any questions, but my laptop has died.
I'm sure that, you know, what we've talked about this morning will evoke different views, different opinions from different sides. But obviously, if you do have any questions on that, please do let us know. What we're going to do is wrap up probably shortly if we haven't got any other questions. I'm hoping that you found this morning useful. Obviously, this is your session, so if there are questions, topics, things that you're interested in, please do let us know either in advance or pop a question on the Q&A. I'm going to give you another few seconds to pop any questions on. And if there aren't any questions, we will take our leave. So thank you for attending this morning. Thank you to all of my colleagues. As you can see, there's quite a lot of knowledge around the room. We have our own discussions about the legislation and our own views as well as our legal views. But I think it's a case of watch this space. This is going to be a moving feast, at least for the next Q&A and possibly beyond. We will bring you any updates that we can on the next one. And if any of you do need anything in the meantime, you know where we are. Please do feel free to reach out. Thanks again for attending, and we will see you all soon.